Good morning, good afternoon, or good evening to each and every one of you, and welcome to today's program, Existential Risks of Nuclear War and Deterrence Through a Legal Lens. This program is sponsored by the International Section of the United States Bar Association and will run for about 1 hour and 30 minutes. Everyone is welcome to pose questions using the Q&A function in your Zoom portal. Without further ado, help me welcome Mr. Jonathan Granoff, President of Global Security Institute and Senior Advisor at the Permanent Secretariat of the World Summits of Nobel Peace Laureates. Jonathan?
Kara, thank you very much. I want to right off the bat thank the International Law Section of the American Bar Association, the New York State Bar Association, especially, and you, Kara, for all the work that you've done to make this happen. Lawyers Committee on Nuclear Policy, where both Professor Moxley and I serve on the board of directors, and the Global Security Institute. The issue of nuclear weapons, we hear in the news each day of the existential risk. Everybody is aware of the Oppenheimer movie. We see it as a crisis du jour, but as Albert Einstein said, the splitting of the atom changed everything except our thinking, and thus we drift toward catastrophe. So our goal in this conversation is to help change our thinking so that lawyers and advocates can use the tool of law to address this existential threat. There's presently less than 13,000 nuclear weapons in the world, and around 4,000 of them are deployed. But we know from some of the science, the climatologists tell us that if less than 200 of these were to go off, it would throw at least 5 million tons of soot into the stratosphere and render the viability of the regenerative processes of the natural world and agriculture so impaired that modern civilization, or even civilization itself, would collapse. And when we read the accounts of what just a relatively small nuclear bomb on Hiroshima and Nagasaki did, it's harrowing. The Stansfield Turner, when he was head of the Central Intelligence Agency, actually wrote prolifically about the unimaginable destructive capacity of these weapons, and pointed out that the flash of light of a 1 megaton bomb would be thousands of times brighter than the sun. That the heat would be 3 times the heat of the surface of the moon, and that within what did he say? Within 100 square miles, the fires would basically destroy everything. So the challenge before us, the destructive capacity, boggles the imagination, and the tools of law are really important in this. So it's a real honor to introduce to you one of the world's great scholars on the subject. Professor Charlie Moxley is a prolific author, graduate of Columbia University Law School. He was a practicing litigator for many years. He teaches this subject at Fordham University Law School. And I recommend all of his writings to you because they're all so they're extremely accessible to even a layperson. He has that unique skill of being able to translate legalese into the English language. And so I want to get right into this dialogue and this interview really with Professor Moxley. And Charlie, how did you get involved in this subject? What brought you to it?
Thank you, Jonathan, and thank you for that gracious introduction and for those remarks. I grew up in the Cold War, and those of us who did, the risks and the concerns about these weapons was pervasive. And it was fresh then, I think it's fair to say. And I think that's important, maybe in a way that we'll have time to talk about today. So I was a political science, international relations major at Fordham College and stayed there for a master's in Russian area studies and just found this area interesting. And then I got into the legal side of it.
So you came to it as an academic and as a citizen.
Yes, and as a student, as somebody trying to understand our world, really.
And so while you were practicing law and litigating, which many people on this Zoom know the demands of such a schedule, you immersed yourself deeply in the study of this subject matter. And what was the most surprising thing you discovered when you took a deep dive into policy and law of nuclear weapons?
It's hard, as you said, Jonathan, as all of us, and I think this is a challenge. And again, maybe we'll have time to talk about this today. We all lead such busy lives, and litigators lead very busy lives, but everybody leads a busy life. But one can make time, and there are committees, there's groups, there are organizations who are engaged in this. And so starting from early in my career as a very young lawyer, I was involved in a bunch of these organizations, as I know you were, Jonathan, and others of our colleagues. So, I mean, I discovered things on two levels, right? I came to understand the enormity of the risk here. It's all about risk and challenge that you were talking about. And then I began to focus on the legal piece. And I think the most riveting thing I discovered is that there is law here. And there's law, and the challenge is, can we harness it and make it, engender in the policy elite, civilian and military, a real understanding, of the law that is here, and let it impact, as you say, on the policy decisions.
Well, I've read I read your books, and today we'll be talking about nuclear, the newest book, Existential Risks of Nuclear War and Deterrence Through a Legal Lens. But what's interesting in your work is its focus on the humanitarian laws of armed conflict contained in the various departments of the United States military. That these are rules of engagement that are taken very seriously within the military. And so you've used the tools of our own military to say, how do we apply this to this particular deployment? But I want to just point out that that in addition to the START treaties, which have reduced the arsenals from over 65,000 to what we have now of less than 13,000, which is not an insignificant accomplishment. That we had an INF treaty, but President Trump pulled out of it. We can't quite figure out why, but that ended that treaty had prevented the targeting of Western Europe by the Russians. By the way, 90% of the arsenal in the world is held by the United States and Russia, and we pretty much mirror each other in having a policy that allows first use of the weapons, and we have enough of them deployed at any moment to devastate each other's countries. But the main legal instrument involved internationally with nuclear weapons is the Nuclear Non-Proliferation Treaty, which has every country in the world except Israel, Pakistan, India, and North Korea as a party to it. And it contains within it an obligation to negotiate nuclear disarmament. And that was part of the bargain to the rest of the world, that the 5 nuclear weapon states under the treaty, the United States, France, Russia, China, and Great Britain, promised in exchange for other countries renouncing the possession of nuclear weapons. So there is a legal obligation. There's also the International Court of Justice unanimously ruled that there's an obligation to negotiate the elimination of nuclear weapons. But so that's the international framework. And the massive reductions that have taken place are used as a rationale for saying that that we're on the right path. But as everybody knows, Russia, for example, has been brandishing them publicly recently after the invasion of Ukraine. What they don't know is that as recently as a few months ago, Russia and the United States in the G20 meeting in India both said that nuclear weapons are inadmissible. We're not quite sure what they mean by that because they're admitting them. I mean, it's like a rule of evidence admissibility, you know. It's not a legal term that I could discern, but they did say that, and they said it also in the G20 in Bali a few months earlier. So we're in a realm in which language, law, and policy are not in harmony, and this is destabilizing and dangerous. And I think that as Americans, we, especially American lawyers, we ought to know what our military considers the law on this subject. And Charlie, I'm going to hand it over to you. And this is really the time for a briefing on what you discovered and what you've written about so extensively from the obligations that our military holds dear based on international humanitarian law.
Thank you so much, Jonathan. I started out as you mentioned, as a litigator. I started in a big firm, Davis Polk and Wardwell, which does some of the biggest cases in the world. And I continued doing large securities and commercial cases for 25, 30 and more years. And then I pivoted into being an arbitrator, a commercial arbitrator and mediator who hears cases. And I hear cases of that type, cases involving millions of dollars, sometimes only thousands and hundreds of thousands, but often millions of dollars of dollars, hundreds of millions, and occasional cases of over $1 billion, huge cases. But even in smaller cases, it is so striking as a person in the legal world that law is taken so seriously, right? I mean, we litigate, certainly in America, but in many other places in the world, one can litigate, one has rights, one can litigate, the courts are there over a wide range of disputes. And lawyers, this is what we do. We deal with one side and the other, and you have a process and you have a solution. But the point is that the meaning of law and the practice of law is very serious, very interrelational, very reactive, right? Because it is adversary. In the common law system, it's totally adversary. Even in the civil law system, you have two sides to a dispute, and you have the judges being a little more engaged as in international arbitration, but there's a dispute. So as you say, Jonathan, the question becomes, where is law in this realm, right? Where is law in this international relations realm and the actions of sovereign countries? Where is law? And for our focus, where is law as concerns nuclear weapons? And I think your starting point is the exact right starting point to look at possession. And then we'll get to obviously use and threat, and really threat is the day-to-day thing. But on the possession level, back in the 70s, there was the NPT. It took place over a number of years, but there is this NPT treaty. Almost every country in the world has signed it. It says, what does it say? It says the nuclear weapons countries will negotiate disengagement, in effect, abolition, disarmament, leading to abolition, and that the non-nuclear countries won't get them. And so the whole purpose of it, and the US and Russia and other countries of relevance here are all signatories to it, right? And so that's there. Just on a broad point, Jonathan, you make the good point of how the numbers have come down, but how we're not satisfied with that. The decrease in the numbers, while important, is a little misleading, because what has happened, and I think we all know this intuitively, one could say in the last decades, but it just transforms so quickly every year. Accuracy has gotten so much better. So if in the Cold War, a country thinking of using a nuclear weapon might use it, it might drop the weapon or target the weapon a half a mile or more from the target. We can deliver weapons, and Russia and China, other countries can as well, with great precision. So you don't need the number of weapons. You don't need the multiple to destroy, as you say, huge areas of the earth. And we'll get to the issue of the conventional weapons. But the reality is, and I want to respond to your question, Jonathan, I want to pivot to the law, but that you raise the interesting point, which is a huge irony here, right? One would think that the U.S. needs nuclear weapons for us to have the policy we have. But the reality, recognized really by everybody, is that if you can do the job in any military context with conventional weapons, then that's how you're going to do it, and that's how you should do it. And the reality is that we've gotten so accurate with these conventional weapons. We can deliver, and other relevant countries can deliver high payload conventional weapons with extraordinary efficiency on targets any place in the world, and do it quickly. So there's an ironic fact that these weapons aren't even necessary. But I think what I'll do, Jonathan, and I want to, let you direct the conversation here, but you've invited me to start talking about the legal piece. So let me just make a 3-minute kind of summary of the legal piece, and then you tell me how you'd like to direct this forward. But we have, as you said, the Non-Proliferation Treaty, which has to do with possession and the obligation to disarm. But then, and I think this becomes the point, right? One wondered for a long time, is there really a body of international law that governs the use of nuclear weapons? And it's now acknowledged by all the nuclear weapons countries. And you mentioned, Jonathan, the Nuclear Weapons Advisory Case of the International Court of Justice of the UN. And in the mid-90s, in 1996, it, as you said, came out with a decision made up of numerous opinions of the different judges on the issue that had been given to it for an advisory opinion on whether it was lawful to use or threaten to use nuclear weapons. And what do we have from that? We have the court's rulings, but we also had, because countries of the world, the nuclear weapons countries, participated in that, and the U.S. put in briefs and arguments. And the U.S., as you say, has spoken often on these issues. There are any number of military manuals and official statements from the U.S. government where it has set forth the U.S. position. And let me summarize it here. Broadly, the U.S. has said, and this point is not controversial, the U.S. has said that the law of armed conflict and the overall body of law of international law concerning the use of force, that it applies to nuclear weapons. We recognize that. Russia recognizes that. The other nuclear weapons countries recognize and did before the ICJ that this body of law applies to nuclear weapons. And let me just say that there are 7 or 8 rules, and we can talk about them, It's something, Jonathan, you and I have talked about so many times, so often. But just to list those rules.
Charlie, explain to people, we're talking about, there's two sets of law relating to armed conflict. One is the law of engaging in armed conflict. That's the threshold of when what are the standards to engage in an armed conflict when there's no other recourse and your country is threatened with devastation, you can use force to defend yourself. Then there is the law of armed conflict, of what you can and can't do in a war. And that law is customary, universal, peremptory. It applies in all wars to all countries at all times. And the United States and Russia as well, before the International Court of Justice, affirmatively said that they are bound by this body of law. And what your work, why I've studied it and gained so much from it, Charlie, what your work has done so clearly is demonstrated and showed the codification of that customary international law in the manuals of the US military itself. And so what does that body of law, under which all countries of the world recognize its guardrails, say about what you can and can't do in the use of force in a war? The laws of armed conflict or the laws of war, customary international humanitarian law, they're basically synonymous. What are the standards that you found out from our manuals, our military manuals?
Yes. As a litigator, as you know, in any case, one is going to be arguing about what is the law, and then what are the facts, and then how does the law apply to the facts? That's disputes. That's litigation. And when I got into this, it struck me that the way to analyze it, because I was looking at the appropriateness of our nuclear policies in our country, and the same point can be made of the policies of Russia and China and France and Great Britain and other nuclear weapons countries. I was just looking at what is the law, and then what are the facts, and then we'll talk about the third piece. And it struck me, why not take the law from the US's own statements of the law? Because in every litigation we do, we end up spending maybe half the time, depending on the case, debating what the law is. So I decided to take that out of the equation. And so in my book and in my writings and articles, and including an article I did with yourself, Jonathan, and with John Burroughs, who is here today, on this part of it, I said, okay, what does the U.S. say the law is? And, you know, the U.S. says that the law of armed conflict applies to nuclear weapons use, and it includes and I'm going to just list the rules, and then we'll talk about them to the extent we have time, but there's a rule of distinction, a rule of proportionality, a rule of necessity. There's an inherent corollary of controllability in each of these rules. There's a rule of precaution, and there's law on reprisal. And when I say what the law is in these regards, it's not speculative. I'm taking it out of the U.S. military manuals and what the U.S. told the ICJ. And, you know, that's the starting point. And ironically, you know, we in the legal field, I mean, when you get to the facts in a case, you talk about, are they in dispute or do you have to prove them? And there's a thing called summary judgment. You know, we can have summary judgment and avoid a jury trial or a judge trial because the issues are clear as a matter of law. And looking at the facts as to nuclear weapons, it quickly seemed evident to me that based on unassailable sources of an international nature recognized by essentially everybody who's a specialist in the field, that the effects of nuclear weapons are known, right? And included in those effects, and this becomes the key to the legal analysis we're going to talk about, are the following, 4 or 5 categories of nuclear weapons. You have a big explosion, right? And you have heat, and you have prompt radiation, which is the radiation right there at the site, which gets burned up with the explosion and the heat. And then you have, so that's going to destroy your area and people and places there, depending on the size of the blast and the like. But then you have the other effects, and they are present with every nuclear weapons explosion. And this is true to the extent of as we lawyers would say, to a summary judgment standard. It's not disputable that you're going to get radiation, radioactive fallout. You're going to have a potential for so-called electromagnetic pulses, which are impacts on electronic devices. And of course, all of modern society turns on having our electronic devices. You're going to have the potential for nuclear winter, and that's from the point you opened with, Jonathan, that you have a big explosion, and particularly if it's near the earth, the ground, it throws up all this dust. And so you're going to have a nuclear winter effect if you have sufficient dust thrown up, as you said, Jonathan, in the opening, to block the sun and destroy the agriculture. And there was a report, and we did a program on this earlier, which we can send to participants later, and Georgetown just published it. But we had an introduction by Alan Robach and James Skoros, Alan Robach at Rutgers and James Skoros at Johns Hopkins, about the impact and effects of the nuclear winter. And the big study by Alan Robach, and there were 11 or 12 other scientists from around the world, client scientists and the like, that the number of deaths from an all-out nuclear war between the U.S. and Russia would be 5 billion. I mean, as you say, it's unimaginable. 5 billion, and so the effects of nuclear weapons are the blast, the heat, the prompt radiation, and then the radioactive fallout, and then the electromagnetic pulse, and then the potential for nuclear winter. And then there's something else, and we'll talk about this a little later, the potential and likelihood in the kind of situations where these weapons would be used, if they were ever used, God forbid, and we hope not, that you'd have a nuclear response and you'd have escalation. So, I mean, that's the parameter. If somebody wants to look seriously at the law in this area, one has to say, okay, these rules, distinction, proportionality, necessity, controllability, precaution, and reprisal, what are these rules? And if you apply them to the effects, including the radioactive fallout, the electromagnetic pulses, the nuclear winter, and potentially the nuclear response and the escalation, what do you get? That's the legal analysis. Do you get lawfulness or do you get unlawfulness? But the standard, the legal standard, I submit, and my work is based on the premise that the legal standard is acknowledged and the U.S., articulates it. These are the rules, and the facts are not disputable, right? I mean, Alan Robach's work, James Skoros's work, which focuses on the uncertainties and the things we don't know as to the extent of the fallout and the nuclear winter and the like. These are all facts as to the risks that are presented.
So let's break this down a little bit. So because what we'll do is we'll lay out what the elements are: proportionality, distinction, etc., prohibition of causing unnecessary suffering, etc. And then we'll talk about the risk analysis that we do apply in terms of responsible behavior regarding how you drive your car, how you take care of your trees on your property that borders on your neighbor,
Springtime.
on how hot the coffee is that you sell at a burger joint. I mean, we have a great body of law that governs our domestic conduct that applies almost in every legal system of the world, that people have to behave in a way that doesn't cause unnecessary risks. But first, Charlie, if you could just break down these elements that you've laid out that are the foundation of recognized black letter law that every major country in the world, in principle, says they are adhering to.
Thanks, Jonathan. And I think, I mean, this is, it's not the sexiest part of the discussion of the policy and all of that, but this is what we lawyers do. And the thing that strikes me, I mean, in the cases I do, I mean, my day job now is as an arbitrator, and I've spent the last couple of weeks on a case involving a securities claim, a securities class action, all kinds of allegations about representations that were made or weren't made, and what the law is or isn't. And lawyers will focus on this at great length. And so what we have here in the international sphere is the same, we have the same situation. We have this body of rules. It's not in dispute. And as you suggest, Jonathan, I'm just going to describe the elements of them, and then we'll get to, how we apply them, and are we taking them seriously when it gets to applying them. But at this first level, it is not controversial, to the best of my understanding and research and study, that the following is the law. As you say, the black letter law. Number one, rule of distinction. It is unlawful to use a weapon that will not distinguish between a legal combatant target and civilians or other protected persons or property. You have to be able to distinguish when you use the weapon, right? And so that's the first level. And so the first level of question as to the lawfulness or not of nuclear weapons use, and we'll talk about threat later, but use is, if we use a nuclear weapon, and we should begin to build into this discussion, Jonathan, low yield nuclear weapons, because it happens, as we've discussed, in our prep, the way the US and other nuclear weapons countries have defended the potential lawfulness of these weapons, most centrally. I mean, almost always, if you go and look at the US statements of defense, including before the ICJ, they don't come in and say, okay, it's okay to use hundreds of kiloton nuclear weapons. I mean, the assertion is that the use generally is lawful or can be lawful. They say, well, no, we can use low yield and we can really control them, and they can distinguish and meet the other legal requirements. So where are we now? We're talking about the first requirement of distinction. And so the question is, can nuclear weapons, if used by US or some other country, can they distinguish military from non-military targets? And that's the question. The way it has played out, and I'll build in the second level a little bit here, and we'll come back and go at it perhaps in a little more depth. But the way it's played out is the US, in its defense of the lawfulness of nuclear weapons, has said, well, yeah, we acknowledge distinction is the rule and it is a requirement, but we're told we can achieve such accuracy. That was the US position before the ICJ. When this question came up, we can, the US lawyer said, and I have the quotes in the book, well, it's assumed that we'll be using some, high kiloton or megaton weapon, and it'll be so expansive, but we can use a limited number of low yield nuclear weapons with great precision at a particular target. right? So that's the question, right? In a
That's
way,
that's a fact question.
right. You have the rule. Can you distinguish? And that's the fact question. So maybe I'll stop there, and I'll lay out the issues for the other rules as well, and then we can talk about application. On proportionality, the basic rule, not controversial, is that you can't use a weapon if its impact upon civilians or protected persons or property would exceed or be disproportionate to the value of the military target. So there's a lot to unpack there, but the basic standard is not controversial. Are you going to have limited enough effects on collateral effects on civilians that the military objective, the immediate and discrete military objective is worth it? So again, that'll be the question. Can we use nuclear weapons in such a limited way that the benefit we'll get? And that's a whole discussion. Is there any potential benefit? We'll talk about self-assured destruction and the effects of the whole of what would follow from an initial use of a nuclear weapon. But can the collateral effects be not disproportionate to the military value? So that's the second test. We'll have to talk about how it applies. And the third is, and it sort of comes in two verbal formulations, you can't use a level of force and destruction even against a combatant, right? The proportionality is largely protecting collateral interests, non-military, civilians and the like. The necessity and the prohibition of unnecessary suffering is more essentially protecting the military. You can only use a level of force that is really necessary here, and it can't have built into it unnecessary suffering. And so that's the third legal standard that we need to say, can nuclear weapons comply with that? What I call a corollary of distinction, proportionality, and necessity rules is the corollary of controllability. And the U.S., in its own statements of customary international law concerning each of these rules, has said that you need controllability. If you can't control the effects of the weapon's use, you can't know that you're going to be distinguishing combatant from non-combatant targets. You can't know that you're going to have a proportionality or a failure of proportionality of collateral versus military effects. And you can't know even whether the level of use you're using is necessary if you don't know what the effect is going to be. So this controllability is important.
So the controllability applies also to the radioactive fallout to neutral states that aren't even party to the conflict.
Of course, yeah, right, exactly. And just to finish up the legal standards, but you've added the neutrality one, which I didn't even include in the original list. But you're absolutely right that neutrality is a protection. The territory, as a matter of international law, recognized by all countries, the territory of neutral states is inviolable. That's the rule, inviolable, and you can't have effects there. Now, the question of how to apply it is an issue. There are two other rules I should mention, and then I'll turn it over to you, Jonathan, in terms of how we go and follow up on this. The two other areas are reprisals. It's a big kind of backup, argument in the back of my back pocket. If I'm a lawyer for the U.S. or Russia or China or France or UK or Israel, for that matter, any country that has nuclear weapons and wants to argue that they can potentially be used legally, the U.S. will say, all right, you have to comply with all these rules of distinction, proportionality, necessity, controllability, for the use to be lawful. But then they say, aha, but you don't have to comply if the other side, if your enemy violated the rules and acted contrary to the rules, then you can do reprisal. And it is true that reprisal is a rule of law that says that a state that's been unlawfully subjected to an unlawful attack or form of attack can respond in reprisal with an act that would otherwise be unlawful. But there are standards on reprisals as well. And the question becomes, what are those standards? Their necessity, proportionality, the intent of the action. And so you can't reprise with a higher level of force than is necessary to address what the unlawful actions you're reprising against, and that you have to have a reasonable proportionality. There's leeway here, but you have to have a proportionality against, vis-a-vis the attack you're responding to. So, and your intent has to be to get the other side to return to lawful compliance. So again, controllability. If you don't have a controllability of a weapon, are you going to be able to even know that that it's limited to within the parameters of the requirement of necessity and that of proportionality under lawful, for a lawful reprisal? How can you comply with that, again, without controllability? And
these rules are being applied in our deployments of American forces. Is that correct?
Yeah, see that, that's the extraordinary thing about this conversation we're having today. I would invite everyone here, and thank you. We've had a wonderful turnout for this. If you just go onto your Google there and you Google the U.S. Department of Defense Law of War Manual, the U.S., and this, as you mentioned, Jonathan, is a good part of how I developed my book and my analysis. But the Law of War Manual is one of numerous manuals that the U.S. government has. They have ones put out by Department of Defense, by Joint Chiefs of Staff, by each of the services. But the Law of War Manual is perhaps the most influential, or certainly among them. It's huge. It's 1,100 pages. And we have, as we can all see in the media, we have JAG lawyers, serious lawyers who go and study international law and get masters in international law at our big universities who are in the targeting rooms, right? So I have not been in the military.
You mean there are lawyers, I know that there are lawyers literally in the room that says you can target this building, you can't target that building based on these manuals?
Absolutely.
Absolutely.
I've talked to so many lawyers from JAG, I've dealt with, interviewed people and had programs.
I want to just pause for a second, Charlie. We're getting feedback from people, cynical, and with some degree of basis for that these rules of engagement are treated haphazardly, to say the least. But the fact is that they're not in many instances, at least in the United States. And if we throw out the compass of the rule of law, then, and we throw out this body of law that we're taking a deep dive into, then what map will we have to bring sanity to policy in the world? Sometimes it takes time for principles to come into practice. I'm always reminded of the power of ought. Max Kampelman made this point when he was an advisor to President Ronald Reagan, that helped persuade him to put in motion this huge reduction of the arsenals. And the point that he made was the founding of the United States was based on, we hold these truths to be self-evident, that all men are created equal and endowed with these rights that we take for granted. Today, when it was stated, it didn't include women, didn't include men without property, didn't include people of color, didn't include indigenous people. It was very inadequate, and we haven't reached this principle yet, but it is the principle that guides us, and we can't throw it out. We need that principle. the principles of law, I think, are in a similar place. And I'm reminded of a statement by the former head of the Strategic Command, General Lee Butler, who said, despite all the evidence, we've yet to fully grasp the monstrous effect of these weapons, that the consequences of their use defy reason, transcending time, space, poisoning the earth, deforming its inhabitants. They're inherently dangerous, hugely expensive, and militarily inefficient. He didn't say that there's a legal failure, because he was a military guy. But people on this call are lawyers, and this is a tool that we have. And I want to say to any of the cynics here, that the tool is not being adequately applied. And it's largely because we haven't studied it, we haven't advocated for it, and it's our responsibility to do so. So now, Charlie, let's go back to the tool. I apologize for this rant, but it is a frustration when you study how America is the first country founded on the rule of law. We have somebody running for president now who doesn't respect it. And we have a population that doesn't understand it fully and its value. And we have a bar association, lawyers, who are not lobbying effectively to come into compliance with the law, largely because they don't know it. And you've just laid out standards of law that our militaries apply in all instances other than nuclear weapons. I wanted to point out, we're even applying it with landmines. We haven't put although there's a convention that we haven't signed, we're adhering to the convention. We haven't put a landmine in the ground since 1991. And when chemical weapons were used in Syria, our then Secretary of State said that this was illegal, even though Syria was not even a party to the convention prohibiting chemical weapons, because it was a weapon that couldn't discriminate between civilians and combatants, and thus violated the laws of war. And just before we go back, there is a treaty now, the Treaty on the Prohibition of Nuclear Weapons, that none of the nuclear weapon states have signed on to, that codifies what we're saying is existing prohibitions. And thus, we as lawyers have a tool for advocacy. And I want to come back to, Charlie, what are the facts? How do they apply to this area of law?
Yes, thanks, Jonathan. And thank you in the audience for the questions, which Jonathan addressed somewhat, and I'll address further as we go on. John Hallen, Dennis Wong, Lewis Cohen, Lakeisha Barnes. Let me first continue and answer Lakeisha Barnes's first question was, what's the other principle, right? I mentioned distinction, proportionality, necessity, prohibition of superfluous injury, unnecessary suffering, corollary of controllability, legal prerequisites for lawful reprisal. And there are other rules, but the one that I would add to the list as the primary ones is the rule of precaution. And the rule of precaution is very broad. I can't pretend that it has very precise, specific elements that are of a limiting nature, but it is, in a broad sense, a rule, and it is embodied in some conventions, some treaties, and recognized by the U.S. and other countries as customary law. The rule of precaution is that a state has to take precaution in terms of its own training of its people, because states only act through people, and in its planning, its training, its weapons acquisition. And that very much ties into, Dennis Wong, your question, when we say precaution, and it even applies to weapons acquisition. And your point, Jonathan, are there really lawyers? There are lawyers in the room where the U.S. is engaged. There are lawyers in the room. And when a strike is being considered, lawyers, it is not unusual, and for strikes of significance, will be asked, is this strike okay? Now, we're always told that it's the commander's decision. That's another level, but law is there. And but on the rule of precaution, I mean, we could spend a couple days on it, but among the policies which are on the factual level that one has to look at and say, are they consistent with the rule of precaution? And I'll mention a half a dozen examples just to illustrate the issues, right? We're still at the point, although time marches on, where we're identifying the issues. But on precaution, the U.S. has a policy of hair trigger alert, and we have a large number of our weapons ready to use at a given time. We have a triad of nuclear weapons where a very significant portion of our weapons, our nuclear weapons, are land-based, non-protected, not deep in a mountain, not deep in hardly not in underground places that are deep and hardened, but rather are vulnerable. All of our ICBMs, as I understand it, any of our planes that are not in the air at a time, that are delivery planes, and our submarines, we have a limited number. What is it now, 13 or so? Whatever the exact number, only maybe 3 or whatever, it varies at time, will be at sea and essentially undetectable, as I understand it. But so many of the weapons are vulnerable, and we've chosen to do it that way. You know, it's not necessary to do it that way, but we have. And the military, including the Joint Chiefs of Staff, have told us that given the setup that we have, the warning time that the president would have to make a decision when he or she would get the word, hey, we are under an attack and are we going to respond? They'd have 10 to 20 minutes, depending on which source you rely on. So there wouldn't be time to do a legal analysis. So much of it would have been pre-programmed, and we'll talk about that in terms of how to respond in given circumstances. There'd be no time for, serious discussion. We have a launch on warning policy where we'll go and, in theory, we'll respond upon our equipment and personnel telling us we're under attack. And we have this ad hoc policy that, well, some uses would be lawful and some unlawful, and you have to wait and see in a context where you're only going to have 10 minutes to wait and see. So the facts there are, or the rule is precaution. You have to take reasonable steps so you'll be able to comply with the law. And the question is whether those policies that I've articulated, and there are numerous other ones that one could mention, comply with the law. And just as one example of the reality that there are alternatives that could better comply, China, for example, for many years, although there are indications this is changing somewhat because there's a buildup there, China for many years separated its delivery vehicles from its warheads. And so its policy is not, we're going to be ready to shoot our weapons within 10 minutes. We have a second strike. We have weapons that no first strike could knock out. And so we'll take our time. So anyhow, let me stop on this. Those are the main rules, as I see it: distinction, proportionality, necessity, controllability, reprisal, law, and precaution. And there's the law, and we can talk about the facts. But let me address one other element. We'll get later, and this is a point that Dennis Wong has mentioned and been concerned about. How does it apply? What difference, in effect? I don't want to overly paraphrase the question, but, does the law really matter here? And, and really that's the question, whether Jonathan and I and Kara and the many folks we have, here in this room now, this virtual room. It's a real question. Are we wasting our time? Is there nothing we can do? And is this just intellectual discussion? Is it all a waste? Or can we make a difference? And I think from the point that Jonathan made earlier, and then I added some detail on it, that we have an engagement with law. We have the law of war manual. We have an asserted policy of complying with the law. And the JAG folks will tell you that every potential use that we would have, and most of the uses, because of the need to act fast, are pre-programmed into the computer. The op plan 12, it used to be COP, or whatever the last I looked, it's an op plan. It's so pre-programmed. But and so that work had, those plans have been reviewed by law. And the reason we're not wasting our time, the reason we can make a difference, and the lawyers in the audience here can make a difference, is that serious lawyers within the government and within JAG are exercising judgment about lawfulness. And what we're doing is we're going to be questioning, when we talk about the application of this law, which they would acknowledge, we're going to be arguing with them and in dispute with them on how you apply it. But if we were to convince them, and I'm convinced that there's a level of good faith within many of the individuals. I don't, there's a level of good faith. So if we can communicate effectively, and if what we're saying is correct, right? I mean, we could be wrong about something, but if our analysis is right about the implications, then they have to integrate it, because it's part of the planning now. All these military manuals are not in the library. They're used for training our military folks. Jonathan and I and John Burroughs and Jeff Biller from the Air Force Academy and others, many others, we did a program, and we'll send you the materials from it, which, as I mentioned, Georgetown Journal of International Law published just yesterday, where we had leading spokespeople from the military giving their view of it. And they didn't agree with Jonathan and John and I and others on all these points, but they're talking about them with us. And if we can, convince people that there's validity to our views, I don't think we're wasting our time. I think we can have impact on the planning.
It's there's no other framework that we can use that is consistent with the existing military structure. And that's really important. And that's why your work, Charlie, is so important. And one of the elements of law that we accept domestically is risk. So how does risk apply to compliance with the use of a weapon? What's the relationship there?
Thank you, Jonathan. And for those of you in the audience who would like to get engaged in this issue, and I think at the end, I think John Burroughs is going to come in and Deeps and talk about LC&P. There are a number of what in academic life are colloquially referred to as juicy legal issues. There are legal issues that I cover in the book, but on many of them, as far as I can tell, I'm among I'm talking about the risk analysis now, among the first people to focus on it. We haven't looked at it. The reality is that everyone recognizes everyone.
Oh, Charlie, just back up.
Yeah.
There are people looking at risk analysis in terms of security issues, but we're looking at it in terms of the law. That's the difference. And the issue as an American is part of our DNA, the very architecture of the identity of our country, based on the rule of law? Or is law just a suggestion? Or is this what our country is about? Is our national identity based on a religious or a cultural identity, or is it based on law? I would contend that America is the first country that was created by a legal instrument, the Constitution. No other country had ever done that before. People hadn't done it. They hadn't created limitations on political power, checks and balances. The fact that we didn't put George Washington as a king. We're founded on that. And thus, the question is, will we apply the law to this new technology that can end civilization, or will we simply look at it as a risk in terms of security, or will we use the tool of law? I think that we need to use this tool. Thus, this analysis of risk in relation to law is extremely important as an American. It may not be important in other countries, but in this country, the most powerful, the leading country, it is very important. So, Charlie, if you could talk about looking at it through the lens of risk as applied to law.
Thank you, Jonathan. And here's how this plays out. We all know, I think, in common life, and I guess, Jonathan, you referred to it, so much of our law is based on risk, our environmental law, our tort law. What level of risk of putting somebody else at risk of injury can one take, and under what circumstances? With respect to nuclear weapons, the analysis has to be done in advance, right? If these rules that I have referred to are going to be applied, it has to be applied now when we're figuring what military actions can legally be taken. You know, if we use this, and that's what these war rooms are like, even in conventional war. You know, if we do this strike, will it comply with law? I mean, if one of us is a JAG officer in the military of the U.S. or some other country that is trying to apply the law, and the commander people come to us and say, we're thinking of this strike, our job as the lawyer, and I've had students at Fordham, you know, who are in the military in different countries, you know, this is going to be their job. Their job is going to be to analyze it. So when we go and analyze distinction, proportionality, necessity, controllability, precaution, reprisal, as against the potential use of nuclear weapons, what are we going to know? We're not going to know what's going to happen. We're going to know what Alan Robach tells us and his other authors on, you know, what the potential effects are, and what James Skoros from Hopkins tell us, and others. We're going to know the potential effects. So that's the question. And it hasn't been examined much. No, so now we're moving into an area where we need analysis that hasn't yet been done. You know, what value do we put on what risks, on particular risks of potential effects of a weapon's use? So if we're going to use, let's say, a nuclear weapon in a given circumstance, or we're being asked, is it lawful? And the commander is telling us, well, it's relatively low yield, and we can deliver it with great precision, and it's against a remote target, and we think it's going to be fine. It's not going to, you know, we're going to discriminate. It's going to be a proportionate effect, not disproportionate. There's not going to be any civilians around. Our job as the lawyer is going to be say, well, wait a minute, you know, suppose it misfires by, you know, X degrees, and it hits this town 50 miles away from the target, you know, that has 1 million people, or this town that's 125 miles from the target that has 8 million people. You know, what's the risk of that? And the commander may say, well, you know, I think I'm going to hit the target, but there's maybe a 20% risk that I'm going to hit that target that has 8 million people. How do we evaluate that? You know, or even if we're going to hit New York or Moscow or Tokyo, and there's like 10, 12 million people, you know, how do we evaluate that risk? That is what we're talking about.
There is a professor, Marty Hellman, at Stanford University, who is one of the people who created the encryption for the internet, who's written extensively about this. And he said, would you get on an airplane if you thought there was a 1 in 100 chance that it was going to crash? What is the risk that you're willing to take in your daily life? And but here we're saying that there actually is a legal standard that has to be established. What is the appropriate? How fast can you drive your car in a snowstorm? The the highway might say that the speed limit is 35 miles an hour, but if you can't see more than 2 feet, if you're going 30 miles an hour and you run over somebody, you would have been driving in an illegal fashion. You would have been, because you couldn't see because of the circumstances. So what are the circumstances and what are the risks in relationship to the use? And this entire realm of this is how we apply the law domestically. It hasn't been applied. By the way, Charlie, you know, Oppenheimer, there's the movie Oppenheimer. And one of the reasons why he had his security clearance taken away was not, as the movie portrays, so much a personal vendetta with somebody, but it was because he wanted to have a public debate on these issues in the 1950s when we were making the hydronuclear bombs, and he wanted to have a public debate. And he never got that public debate. So he, along with Albert Einstein and Bertrand Russell and Joseph Rotblat, who walked off the Manhattan Project and won a Nobel Prize for it, formed the World Academy of Art and Science, where I personally serve as a trustee and a fellow, to focus on not just the science of destruction and nuclear weapons and other things, but the arts that are needed to constrain and contain and eliminate these threats. One of the arts being the art of law. And so there, as you pointed out, there are organizations like Lawyers Committee on Nuclear Policy, Global Security Institute, where I serve as the president. And then of course there is a treaty trying to prohibit the weapon itself. The fact is that 2 years ago, I think it was 2 years ago, the Human Rights Commission of the United Nations declared that the threat or use itself was a violation of human rights. So while the news shows what looks like a breakdown of international order and law, the fact is that at the same time, there is the advocacy for strengthening it, for strengthening the International Court of Justice, for strengthening the International Criminal Court. And the game is not over. So I want to say to the cynics listening to this, we are still in the game and we need to use this tool. Charlie, what is the best way for people what do they need to learn and what do they need to do to use the tool of law as an element of advocacy to make our policies a little bit saner, a little bit safer, and in compliance with the law?
Right. I mean, this is really the question we talk about all the time is how can we make a difference? I mentioned when you were, opening up the topic of my background, Jonathan, and how I got involved in all this. I think being of that Cold War, you're growing up in the Cold War generation, I think it was fresh. I mean, my parents had been Second World War vintage, and now the Cold War is there. I was a kid, with the Cuban Missile Crisis, and it was front of mind. And I think, Jonathan, in a sense, the deepest answer to your question of how can we make a difference, how can we change, how can law matter here, is it's a consciousness raising thing. I mean, we've all learned something. Maybe some of you have read some Daniel Kahneman, Thinking Fast and, Systems 1 and Systems 2, Thinking Fast and Slow. Malcolm Gladwell has the book Blink. So much of our thinking as humans, I mean, we're limited. And so much of our thinking is unconscious and automatic, and it takes so much effort to bring things to consciousness. I think, and there's another issue. I'm going to build this in and then I'm going to try to make the point, Jonathan, that answers your question. Think of us as lawyers. What do? We make a living as a lawyer. I mean, being a lawyer is a calling, but we make a living. If we're in the litigation side of it, we tend to identify with our clients. And I can be a securities lawyer and I can be representing one issue, a client with one issue, and then in the client, 3 years later with a totally different issue. We have an identity with our client. So what do we have in the government? We have very serious civilian and military leaders, educated, intelligent, moral people, many of them, probably all of them. I mean, good, serious people. But I think there's a mindset issue. There was a prof at Georgetown, I'll think of his name, who wrote an article, who had been in the military, and he said that, lawyers and officials within the military, particularly lawyers, think with their clients. They want to be identified with them. And so I think the challenge on your question, Jonathan, how do we go and make a difference, is to, we talk in the legal area, in the area of art, that a child or an artist sees things with an original vision and directly, and isn't thinking in Daniel Kahneman's way of so much that we don't see. I think we have to bring to consciousness these issues. I think we have to take these legal issues, develop them, and talk about how to apply them, and have an ability to convince people. But I think we have work to do. Like, there was an example that came out of that conference that we did back in November of last year that we'll be sending everybody the Georgetown publication of the proceedings of, where the question came up, if we're a military lawyer responsible to make a judgment advising the military on lawfulness of a use of a weapon, what level of knowledge do we have to have? What level of assurance? And, coming from my world of commercial securities practice, if one is going to give an opinion letter that something is lawful to a client, what do we have to do? We have to investigate. We have to know. We have to have a good, solid legal and factual basis for it. But it appears that the military's view on this, I think we need to work on this, and I can't pretend to state it precisely because I'm not sure it's precisely formulated, but it is more broadly that, well, we need to not know it's unlawful. And that can't be the rule for the potential for using nuclear weapons with the impacts they have. So, that's an example, one of any number where, we need to develop our arguments, which is what I've tried to do in the book. I mean, it goes on on all these things. Develop the arguments, kick the tires on them, engage with the folks who are involved in our establishment, military and civilian leadership, and try to, convince them we're right if we are, and get some engagement on changing our policies and practices.
I want to highlight that first, there are a lot of people in the military agree with us that these weapons are not usable, they're incredibly hazardous, and we should work to get rid of them. And by that, I'd say, for example, former Secretary of Defense William Perry has written extensively upon this. Robert McNamara, former Secretary of Defense. General Butler, who was head of the Strategic Command, talked about how he said, I came away from the experience of being in that position deeply troubled by what I see as the burden of building and maintaining these arsenals, the tangled web of policy and strategy, the number of weapons, the delivery systems multiply, the staggering costs, the pressure of advancing the technology, the grossly destructive war plans, the daily operational risks, and the constant prospect of a crisis that would hold the fate of entire societies at risk, which is where we are today. We're in a crisis where nuclear weapons are being brandished. And then General Butler said, what concerned him, missiles that blew up in their silos and ejected their nuclear warheads outside the confines of the silo, B-52 aircraft that collided with tankers and scattered nuclear weapons across the coast and into the offshore seas of Spain, a B-52 bomber with nuclear weapons aboard that crashed in North Carolina. And on investigation, it was discovered that one of those weapons, 6 of the 7 safety devices that prevent a nuclear explosion, had failed as a result of the crash. There are dozens of such incidents, nuclear missile-laden submarines that experience catastrophic accidents and now lie at the bottom of the ocean. We know that in the Cuban Missile Crisis, the Joint Chiefs wanted to invade Cuba, and the missiles were operational. Had we invaded, they would have been used. We know that in 1995, a weather satellite was launched off the coast of Norway. And although the Norwegians, I told the Russians that they were doing this, it didn't get passed up the command and control. And Boris Yeltsin, who was the president of Russia at the time, was not told about this. And he was told that there was something that looked like a Trident missile launch that would be a electromagnetic pulse explosion over Moscow in less than 8 minutes that would destroy the command and control of Russia. And he said that he wasn't worried because he knew Bill Clinton. It came down to that human being. It came down to there was a computer chip in one of our satellites that couldn't distinguish between a sunrise and a missile launches. There was a cloud formation that in 1983 that looked like a full-scale American launch, and one man, Stanislav Petrov, didn't pass the information up the command and control because he said 11,000 nuclear bombs would have rained on the United States. These risks that we're talking about, these daily risks, are very real. And I believe that if the public knew of these risks, and they knew of the tools of law, and they knew that we take these tools seriously, the debate could be very different. And that's why I recommend everybody read Charlie's book, because he makes the case so effectively that our policy that gives us the legitimacy as Americans is to abide by these laws. But we're not, it appears to me, Charlie, do you think, are we abiding by these laws with respect to nuclear policy?
Yeah, I think we unquestionably are not. And I think that's the problem. I think the policies we have, and let's step back for a minute. I mean, we've talked about use, and the broader question, the more prosaic day-to-day question is deterrence, right? We have a policy of deterrence, other countries do. I think in a way, that's why there is a complacency and a public acceptance broadly. I mean, maybe if you could probably get any result out of a survey, but deterrence is intuitive, right? Oh, we're going to have the weapons, and the repercussions are so great, so the other side's not going to use them, and they're going to think the same thing about us. And if you could trust deterrence and it would last for a millennium, it might be one thing. And I've been reading these questions when I look aside a little, and Jonathan's been doing the same thing. We're trying to respond as we go along to some of the points made in the colloquies from participants here, but the rules are there. And a number of you have said, okay, well, let's have a global movement. Well, we had a global movement during the Cold War. Obviously, right now we have, a situation, particularly with Russia and the Ukraine, that I don't think you'll hear from Jonathan or I or others that, well, the diplomats are going to get together and have a drink and we're going to have the human element. But that will come back again. I mean, Morton Halperin, whom we respect, has written a lot on this, and he has suggested that when the Ukraine situation is resolved, hopefully there'll be a level at some point in the finite future of sanity, and people can talk again. And then we can have a global movement. And I don't think Jonathan or I or any of our friends and colleagues, who are so concerned about this, we're not talking about unilateral disarmament. I'm not. I'm saying there are legal issues here, as Jonathan has argued this, here and other occasions so eloquently. The United States is built on law. We should be the leaders, but we're not under illusions that you're going to have compliance. There have been terrible non-compliances by other countries, and arguably there have been non-compliances by our country. We haven't been so great on compliance with international law either, and that's another subject. but we can have verification, and that's the point. You know, we should recognize the law, have the dialogue, and I'm sorry, you know, and have the dialogue when we can do it, but the resolution is going to include verification.
You know, there's also, from the point of view of risk, there's a lot of things that could be done right now that are fairly modest that would reduce the risk, such as adopting a sole purpose or a no first use policy. That's not so distant. I mean, Joe Biden ran on that as part of the platform of the Democratic Party, but our nuclear posture review didn't incorporate what the platform of the Democratic Party was. China actually has a formal no first use policy. India has a no first use policy. So that would be a huge step. There are grassroots movements, Charlie, like I'm in a group called Voices for a World Free of Nuclear Weapons in the United Religions Initiative, bringing the issue in the moral issue. My political mentor, Alan Cranston, used to say nuclear weapons are unworthy of civilization. They're just immoral. But there also is a movement called Back from the Brink that is advocating advancing the treaty on the prohibition of nuclear weapons, that puts before us the fact that there is a legal instrument that could move us there. But the main thing is the Nuclear Non-Proliferation Treaty has a bunch of threat-reducing steps in it that we've already committed to, that we're not living up to because the political pressure is lacking. And that's where I think the scholarship that you've been doing is a very, very important tool for that advocacy. And I always think, when you talk to people about, you know, the logic of this, and you say, well, what if the Biological Weapons Convention came into effect with Richard Nixon? The Nuclear Non-Proliferation Treaty came into effect with Richard Nixon in 1970. The movement toward the abolition of nuclear weapons in government that took us down to the much lower numbers was with Ronald Reagan. This has not been a partisan issue. This is an issue of smart, dumb, right, wrong, sanity, insanity. And we can't allow the issue to be framed as partisan. I think it should be framed as moral and legal. Is it the right thing to do to have these weapons on alert status every day? And is it the legal thing to do? And I think the legal argument is very, very powerful. I mean, Charlie, in the seminar that you helped put together with the lawyers from the U.S. military, I don't think they made the argument very effectively.
No, I mean, what I think is that it's our policy. If one is a lawyer or a high official, one has to defend the policy. And I think the policy is unfounded. It's not the first unfounded policy. Deterrence may have made sense at the end of the Cold War, at the end of the Second World War, right? We wanted to demobilize, and we thought we'll have these weapons, and they'll prevent adversaries coming against the Soviet Union coming against us, so we won't put the money into conventional weapons buildup. So deterrence was the theory. But in the questions that people have posed us, they've said, well, how likely is the risk? And the point has been made, not just the point you've been making, Jonathan, of the risk of unintended or accidental use, but also, and I have a chapter in the book on this, but I can't read this. G. Glass has referred to the Cuban Missile Crisis and the potential use there, and another participant here has referred to Vietnam, the consideration. There's any number of times when we talked about using them, and another person here, participant, has said, what about sole presidential authority? There are obvious issues here that when one says how grave is the risk, that we have these policies of high alert levels, launch on warning, vulnerability of probably percent. I don't know I'd have to think about the exact number, a high percent of our nuclear weapons, and quick alert levels and quick response and a built-in machismo. And so the risk is great. I mean, 90 seconds before doomsday is that the latest? But the risks are there because the policy assumes lawfulness. And it's what I've heard Professor David Koplow from Georgetown refer to as kind of a bait and switch, because our defense of the lawfulness before the ICJ of nuclear weapons threat and use is, okay, it's potentially lawful to use low-yield nuclear weapons. That was the argument. But what is our arsenal made of? I can tell you now. I mean, we have the exact numbers. Our arsenal, we have 100 deployed low-yield nuclear weapons. And we have, as Jonathan gave the numbers early on, we have thousands of other weapons, and they're not low yield, they're high yield. So we have a high risk thing, we have a volatility, but we have an underlying commitment to rule of law. But I think we've lost our understanding in our government leadership and military, more the civilian than the military. As you said, Jonathan, the military folks understand the risks here, but their hands are tied, right? I mean, they are non-political. And so the civilian leadership, there's been a failure of understanding here, as to the risks. And of course, there's a lot of money involved. And so the challenge is to communicate the realities and penetrate people's psychological element of denial as to the risks here.
The lawyer you cited, David Koplow, was deputy chief counsel of the Defense Department, and he is very much involved with us in this cause. That's the irony of the situation, is that so many people who have been close to the arsenal and close to these issues feel strongly that we should be moving in the direction of abolition. I often think of the unspoken cost of the weapons, not just the trillions of dollars of money, but the fact that it institutionalizes adversity. And it thus privileges those parts of government that are wedded to that adversity. So while we have this adversity, while Russia felt threatened by us, and now that they have clearly violated the respect for international law in the invasion of Ukraine, and of course, the United States violated international law in the invasion of Iraq. This is the problem. The law is our tool, is our guardrail, and when it's violated, it becomes really hazardous for us in the nuclear age. And it's going to become increasingly hazardous with the involvement of artificial intelligence, which will speed up the processes. In each of the instances in which we've come close to the unintended consequence of use, it has been an individual human being who said, wait, let's look at this more carefully. Let's make sure that we stop. And artificial intelligence is going to be speeding up the process. Everything's going to be faster, and it's going to make that all the more difficult to stop the process. So to me, we've got to be highlighting the universal need for lowering the risk and bringing us into compliance with these recognized international rules of law.
We are unfortunately running out of time. Jonathan and I and John Burroughs and others, we will do other programs, and we'll certainly, I wish we had more time, but before we close, just one comment, and then I want to ask Kara to bring on the camera John Burroughs, who has been the leader of LCNP for many years, and we have a new managing director, Deep Vij, and she's going to make an appearance, and Jonathan is going to give you a email address to communicate to him. John will, and you can communicate to Jonathan and me as well. We'd love to get you engaged. And I'm going to ask Kara after that if we can just invite the audience in and just have an informal discussion afterwards for whoever can come. One question we didn't get to, and we should, Jonathan, John, have a subsequent program on this. Somebody said, what's the prospect of litigation? And we are talking about that. There has been litigation in the past. There are challenges to it, which the lawyers will recognize in terms of political question, standing, sovereign immunity, self-executing or non-self-executing treaties. It's hard to get a court to hear these issues, but we're always looking for it and anxious to have a potential for litigation if we can identify a good one. But I'll stop here and turn it over to you, Jonathan, and John. And Deeps. Hi, Deeps.
Yes, good afternoon. Hi, Jonathan. Hi, Charles. Hi, John.
Yes, well,
everyone else as well.
Charlie and Jonathan, thanks for this really rich conversation. I want to first underline that Professor Moxley, Charlie, has a new book coming out, and it's entitled Nuclear Weapons and International Law, Existential Risks of Nuclear War and Deterrence Through a Legal Lens. Correct me if I'm wrong, Charlie, but it's scheduled for release in May, and you can find it on the Rowman and Littlefield website. So if you want to dig into these issues, I highly recommend the book. In terms of Lawyers Committee on Nuclear Policy, we have endeavored, not with a great deal of success, I suppose, but we have endeavored to involve lawyers in our work, and we would like to be successful at that. And you can contact us at contact@lcnp.org. Jonathan, I don't know how much time there is left. There's one substantive comment I would make if there's time.
Do it.
Right. So reprisal is an extremely important issue because arguably that's really the way the US military is thinking about the question, is that they are prepared to use nuclear weapons second if they deem it necessary. And Charlie talked about some of the rules that apply to reprisals. But I want to also say that there's a very good argument that it is prohibited to undertake strikes in reprisal against civilian population and civilian infrastructure. This is a rule that's in the Geneva Conventions, or more precisely, Protocol 1 to the Geneva Conventions. It's a rule that Professors Weiner and Sagan have argued is now customary international law applying to all states. Professor Weiner participated in last November's webinar. So I just wanted to underline that reprisal is not sort of a wide open thing that's about vengeance. It's subject to rules, and its purpose is to induce the enemy to stop committing unlawful acts. It's not a license to do whatever you want. I'll stop there.
Deeps, would you like to say anything?
Yes, well, good afternoon, and thank you for a very intriguing webinar. I was typing my question in until we ran out of time, but I just wanted to add to what John has said. You know, we're looking to roll out some events and programs to engage lawyers, the legal fraternity, more extensively, and we will send those notifications out. I just had kind of a comment as well as a question. I was really intrigued by the question Jonathan asked about the rule of law and how that kind of seems to be very specific to America and what that means in terms of nuclear policy. And I also teach American government, and I was really intrigued by that comment, and I wanted to see what Charles, as well as Jonathan and everybody else here who might have something to say about it, is that where, the Constitution, of course, lays down our rights, but it also really lays down the jurisdiction of the state versus federal powers so as to maintain any kind of infringement against our rights in many ways. Having said that, where do you see nuclear winter as an argument featuring in this kind of constitutional umbrella of really talking about how that would impact our rights in any way at all? And what, in your view, is some of the main obstacles in syncing or bringing closer international norms and rules to domestic norms and rules on nuclear policy? Just very broad questions and your thoughts on any of these.
Let me make one comment, and I'd love to hear Jonathan's take on this, but it's an important question. But in a way, it's the most central question, because we didn't have the next hour that we would have needed to talk about the application of each of these rules, to the facts that we know about. But the way the U.S. military have gotten around arguments that they can't comply is to say we can hit the target accurately, and you don't need to consider things like radioactive fallout, electromagnetic pulses, and nuclear winter. But I've argued, in my book, and I pull it right out of the U.S. military manuals and statements, that in applying these rules of the law of armed conflict, the potential effects one needs to consider are all non-speculative, foreseeable effects. So, and these effects are not speculative. We know you're going to have radioactive fallout. We know, depending on the height of the burst, there's going to be EMPs, and we know there's going to be nuclear winter beyond a certain number of nuclear weapons being used, and the level at the height of from the ground at which they're used. And indeed, and this is a much bigger legal discussion, but we know that there, in the extreme circumstances where a nuclear weapons country might use these weapons, certainly the U.S. And probably Russia, China, it would be an extreme situation, right? And if you had a use in those situations, the likelihood of escalation and counterattack would be substantial. So the answer, I think, to your question is that all of the identifiable potential effects of a weapon's use are relevant to the legal analysis, including the nuclear winter. Right.
Thank you.
When the issue was before the International Court of Justice, the hypothetical was placed before them that precluded their coming to the conclusion that in all instances, nuclear weapons would violate these standards of international law. A depth charge on the high seas, a use in the Gobi Desert, the exception, as if that's the actual deployments, as if that's the norm. And I view that as there are speed limits. But if somebody say somebody's delivering a baby and they are having complications and they're starting to bleed out, and you have to break the speed limit to get them to a hospital, you break the speed limit, you're not going to get a ticket. It doesn't mean you throw out the speed limits. And that's kind of the way people are interpreting this. Saying, because the court couldn't decide that in all instances, nuclear weapons are not prohibited, therefore, we have no prohibitions in our deployments. They neglect to say, well, that we actually have to be able to have proportion. What's a proportionality with a megaton nuclear weapon? What's a proportionality with not inflicting unnecessary suffering when we know the horrors of Hiroshima, and Nagasaki. And these are relatively small weapons. And then the idea of innocent billions of people being affected by it, and neutral countries not being able to control radioactivity in space or time. They hung their hat on the exception in the case before the court. The court said, we're not deciding that it's legal, but we don't have the evidence for these hypotheticals because that wasn't what was really presented. So I don't know. I thought this was a very dishonest sand in the process. It jammed it up. We have yet to figure out how to get standing in a domestic court in the United States to clearly argue these issues, because the injury is speculative, and to get in front of get a case or controversy under our system. I mean, just imagine the after a use, what courts would there be? And how much respect would there be for the institution of law after the shock and devastation of these weapons? That's why this advocacy is so important, so that it never happens.
I see from Kara that we need to end. I mean, we had said we'd end at past, but we will schedule a further discussion. But let me ask you, Kara, you can turn off the recording, but can you invite? I mean, can you let people who are in attendance just come in and be visible, and then let's just have an informal discussion?
But Charlie, for the taping, could you give the final word, please?
Yes. Go ahead, Charlie.
Thank you. Thank you. The final word. I think the final word we'd all like to hear is the substantive one, that law matters, that the facts and the law are not in dispute, and that there is a solid basis. And we invite everyone to look at my book and writings of Jonathan Granoff and John Burroughs and others. I mean, there's a literature out there to the effect that if one applies known established international law to indisputable facts, that in virtually all circumstances, you're going to have unlawfulness. And the point that Jonathan ended on is such a solid one. I have in the book any number of statements from the U.S. military manuals that says that one should evaluate the lawfulness of a weapon from its typical or intended use. But our policy, when our lawyers have argued the thing before the ICJ, was that, well, let's look at the remote, the one weapon or a small number at a remote site in the sea or the desert. So anyhow, I'll rest on an assertion that there's law here and that there is a solid basis for concluding per se broad unlawfulness. But I'd invite you to, invite the people here to engage with, as John said in Deeps, contact LCNP, contact Kara at the State Bar for the international section at the State Bar, which is a wonderful group, and get involved. So thank you all. And Jonathan, thank you for organizing this, and thank you, Kara, for administering it and getting this going.